we have something that is sort of unique, I think, to Florida and maybe one other state, which is known as homestead protection. I wanted you to touch on what's the difference between a personal residence that's my homestead and a vacation property or a non-homestead property. Why do we care, and how does it affect this Medicaid asset test?
Yeah, first, I think it's important to mention that when we tell people that you can only have $2,000 worth of assets, that only refers to countable assets. And luckily, not every asset is countable. So the homestead, real estate in general. If you are a single individual and you have a homestead, if the value of that, the equity of that homestead is less than $595,000, then you don't have to worry about it being counted as an asset. So what happens is most people who are coming to me, their homes for Medicaid planning, their homes are worth under that, and it's not an issue most of the time. But occasionally you have people who they have a house that's worth $700,000. And I have to tell those people a few things. Number one, I ask them, is there a mortgage? Because it's not the value of the house. That's why I corrected myself. It's not the value of the house that counts. It's the equity, right? So if you have a $700,000 house that has a $200,000 mortgage associated with it, then you have $500,000 worth of equity. You are under that equity limit and you are fine. If you have a $700,000 house and you have the mortgages all paid off, well, now we're talking to our clients about things like taking out a small mortgage. And so they're going to enrich themselves by an extra $200,000, but they're going to draw down the equity, and we now have other ways of protecting that money. So there's some exceptions to that. That's for a single individual. If we have a married individual, as long as there's anybody who is dependent on living in that house, we have a spouse, we have kids, sometimes they're adult disabled children, then the house can be worth $1 billion and Medicaid can't count it against you. As long as there's someone else who's not receiving Medicaid, or there's someone else living in that house who's dependent on living there, then value is never going to be an issue. So those are the basic homestead rules. We have some people who have extra second homes, vacation homes, or rental properties and things like that. And the other way you can take a piece of real estate and make it turn it into a non-countable asset is if you rent it out. So people have vacation homes and they want to keep it in the family. I go, you got to rent it out to someone for something that's approaching fair market value. So what I mean by that is you can't rent it out to your son for $100 a month if the fair market value rent is $2,000 a month, right? So as long as it's fair market value, once you rent it out, now that's more income coming in, right? So that might mean we have more money we put into a qualified income trust or a pooled special needs trust, but now this big, huge asset is protected. And we have other things that we can do to make sure that after our client passes away, even that property is not subject to Medicaid estate recovery.
One situation, and I don't know how frequently this happens, but just as you're talking, I'm envisioning the situation where it's, I don't have a spouse or anyone else living in the house. Maybe they predeceased me. I move into an assisted living facility. I lived there for a few years. And the next thing you know, I'm in a nursing home and I'm applying for Medicaid, but I haven't lived in my house for a while. Right. How does that work? I mean, is that still treated the same way?
Yeah. So those people have to make a choice. So yeah, if you are not living in the house, Medicaid takes the position that if you have what's called an intent to return home, then they will still not count that asset against you, even if it's unlikely, right? Even if you're in a nursing home and there's no way you're ever leaving that nursing facility because you need 24/7 care, as long as you have the intent to return home. And what I tell people is, if you were to walk into a nursing home and ask everybody in that nursing home, would you like to go home? Would you like to go home? Would you like to go home? They would all say yes, even if it's never going to happen. So Medicaid will assume that they have the intent to return home unless they're renting it out, right? Or unless they are, right. They've done something else to show they've done something else to show that they don't intend to return home. It won't be an issue. Some people, though, they're in a nursing home. especially in a nursing home setting, right? Because all of your income goes to the facility. You don't get to keep income set aside for paying the taxes and the upkeep and the utilities and the cable bill and, you know, all these things that come along, all these expenses that come along with home ownership. So some people say, well, I'd prefer to sell my house if you don't have family who's willing to kind of take over those sorts of payments. So we deal with both scenarios. And the answer is yes, we can sell the house and use other Medicaid planning techniques to protect their access to these benefits. Or if they want to keep the house and not deal with it, then we can now save it as a, you know, sometimes we convince family members, listen, you have an interest in paying these expenses because this is your inheritance, essentially. So pay the tax bill, pay the insurance, and you'll get the house after mom or dad passes away, and we can work that way too. So kind of whatever people want to do with their real estate, we're able to assist.
Oh, that's a no-brainer. And the last thing here on real estate before we move on to another asset type is you hear a lot about what's called a Ladybird deed. What are they and sort of how do they fit into all this?
Yeah, so Ladybird Deeds are a really common estate planning technique that we use. And it's really not a Medicaid planning technique when it's dealing with your homestead. It's more just good, solid estate planning. So if the house is just in Mr. Smith's name and Mr. Smith passes away, his heirs have to find his will. They got to go to the probate court and they got to go through that whole process before getting the judge to order title to go to whoever it's supposed to go to. A Ladybird deed can circumvent all that. And essentially what a Ladybird deed says is, I, Mr. Smith, deed this property to myself to do with whatever I want for the rest of my life. And if I don't sell it or do anything else with it, and I pass away, then the deed says who gets the property. And it's like magic, right? After they pass away, you record the death certificate and it's immediately now owned by whoever's listed in that deed. The reason why it's important to structure the deed that way, as opposed to there's regular life estates, and there's just sometimes people go, let's just put the house in the name of my son or daughter or both of them and let them be joint owners. And the reason why we don't want to do joint ownership, we want to do the Ladybird deed, is because the big no-no with Medicaid is there's no gifting allowed. You can't take assets and give it to someone who's not your spouse. You can actually give to your spouse. You can't give anything away to the kids. And the Ladybird deed avoids that problem because they're in fact not giving anything to anybody as long as they're alive, because they retain the right to take it back or to change the beneficiary designations. And so only after they pass away, what does the interest in fact change to, and we avoid the gifting penalty, and we also avoid probate. So for a homestead's not going to be counted. It's not going to go through, homestead's creditor protected. Medicaid is not any better or worse placement than FPL or Visa in terms of how creditors are able to attach themselves to assets. So if it's your homestead, the Ladybird deed is not a Medicaid planning tool, it's just good estate planning. But for income producing property, the Ladybird deed is great because as long as we can get the asset to avoid probate, Medicaid won't be able to touch it in Florida. And that's also a very Florida unique rule that is not always the case in many other states.